And at this time, I am going to turn it over to Rick Roberts, who is representing the Louisiana Real Estate Commission, as well as Patty McMurray on behalf of Baker Donaldson, as they roll through the changes to both the property disclosure form as well as the statewide buy-sell agreement. Take it away.
Thanks, Amy. Appreciate it. Thanks, everybody, for attending. Yes, I'm Rick Roberts, Louisiana Real Estate Commission. I'm the chair of the Forms Committee. Of course, we have Patty McMurray with us from Baker Donaldson, and she was instrumental in getting this this current form to you in its present format. But listen, before we start, let me just do a little quick history. You know, this is a collaborative effort with Louisiana Realtors and Louisiana Real Estate Commission. Every 2 years, we review both the buy-sell agreement and the property disclosure document. And it's just an effort to keep us up to date with not only the changes that are happening in the industry, but also what works for us out in the field and things that need to be added, changed, amended as we see fit, and what we get as far as feedback, not only from practitioners, but the committee that gets together every 2 years is a collaboration of managers, practitioners, title attorneys, and we take input from everyone, including the consumers. So again, that's how we get here every 2 years. Let me just a little bit of housekeeping. I have to thank some people before we get started. First and foremost, Linda Butler, who's the chair of this committee, who has been from the onset since we enacted and changed the law for a statewide contract. I think, geez, maybe 13 years ago. I've been a member as well. But also, Amy, thank you for Louisiana Realtors for helping us out with this. Of course, Summer Meir at the Real Estate Commission has helped us as well. But I got really special thanks for the people who really done the heavy lifting on this project. And Ryan Shaw at the Louisiana Real Estate Commission is probably cross-eyed from going through the many versions and changes and footnotes and things that we've sent her. And she's been able to format and put all together wonderfully and make the lines match up. So special thanks to her. Kim Calloway with Louisiana Realtors. I kind of liked Kim before. I don't know if I do so much now because she calls me all the time about different ideas and thoughts and changes she has. But I'm just joking. So Kim Calloway, thank you so much. And of course, Patty McMurray, thank you. You know, a lot of this is you know, your efforts. And I will say this, anybody who's seen the flow chart, the colored flow chart that kind of walks you through the due diligence inspection period and the different options there, Patty is responsible for that. I'd like to take credit for it, but I can't, especially since she's on the call and you know, she is an attorney. So Patty, thank you for that. I most appreciate it. So I think we can probably get started. So of course, we'll start with the property disclosure document. And this, basically, you know, this is who completes the form, and it's basically everyone now. So in all these forms, of course, I should have mentioned earlier, both property disclosure, buy-sell agreement, all the deposit addendums, sewer addendums, all that can be found on Louisiana Real Estate Commission in both a fillable format and a regular PDF, along with the articles that are posted for both as well for educational purposes. So let's go on to the next slide, Amy. So who is exempt? This is a little different change, and Patty, help me if I get off base here, where now the exemption form, there will be a spot for all to check, because we added, if you look down at number 15, none of the exemptions above apply to the seller. So they would check that box, sign below, and then proceed on to filling out the rest of the property disclosure. In the past, we did not have that. So only thing that applied here is if there was an exemption. So now all will fill out one of those boxes, if not more, if there's other exemptions that apply. But if there's no exemptions, they would check box 15, sign, and then move forward on the property disclosure document. Is that fair to say, Patty?
Yes, and I think, you know, the idea was those first 2 pages of the property disclosure document are really about who is exempt and who needs to fill it out. And not everybody was really looking at that. And because now these are check boxes, I think sellers will really have to look through to see, do I need to check any of these boxes, and actually read, you know, what these exemptions are. but all sellers should check a box on page 1. Either they're exempt and they've checked the box 1 through 14 for what that exemption is, or they've checked box 15, which is I don't have an exemption. So everybody checks a box, page 1.
Okay. So now the exemption form, we of course added 4 spots for both buyers and sellers. So again, just formatting there. Again, all will check one of the 15 boxes and sign the exemption form, but all buyers and sellers. And again, we've increased the buyer and seller spots to 4 on all the forms. Okay, so we did add for our folks in Livingston Parish. I won't go into the weeds on it, but we did add a question for pump grinder systems that are apparently big in Livingston Parish, and there's some penalties for licensees who do not disclose or have their sellers disclose the existence and the pump grinders if there is a system and if it's been updated. So we did add that. Again, this is a statewide form, so we try to incorporate everyone, and that's what you'll see there. We did also added the instead of just alarm security systems and audio video surveillance alarms, those things are now in vogue. And again, if they are leased or owned is another significant question. So we did modify that particular question with regards to video systems and security. Again, a lot of reformatting there. So here's the biggest change on the property disclosure document, and it's regarding the flood section. And in the past, on our current document, it's kind of broken up where you talk about the lot and land, has it flooded, and you answer some more questions, and you talk about has a structure ever taken on water. What we basically did is codified everything regarding flood into section 6, which is on page 6 of your property disclosure document, and actually goes on to page 7 and bleeds on to page 8. So the basic takeaway here, and Patty can fill in some of the granular stuff, is if your seller has received any money whatsoever regarding flooding from any governmental entity, your sellers need to pay particular attention to this section and fill it out to the best of their ability. We have special flood hazard areas that are covered. We have FEMA areas, questions that are covered. Next slide, Amy, I think. Yeah, private flood insurance, questions regarding flood insurance, and if there's any claims made on the policies, NFIP, any claims that are, made, provided in the section, and of course, federal disaster relief, and that also applies to the obtain and maintain. And that is something where this is the initial notice to the prospective buyer on the flood insurance, if there was money given from a governmental entity, and if there's a requirement to obtain and maintain. Is that fair to say, Patty, that
yes.
as far as flood?
Yes, and I think during the process of working on this property disclosure document, and particularly those flood assistance and flood insurance questions, we actually had multiple meetings with FEMA representatives to get their input on the questions and on providing notice about receipt of monies for flood claims. So for the most part, they were very complimentary of the way the form was. But the new questions that you see on there were in coordination with the FEMA representatives and some recommendations that we got from them. So hopefully they will be very helpful in letting buyers know that there's potentially a need to obtain and maintain flood insurance on the property if it's ever received funding for any claims made previously. So we do hope it will help both buyers and sellers with that information.
And again, folks, it's all in one spot now. You don't have to go back and forth. Everything regarding flood, whether it's the property, the structure, NFIP, road home, is all in one section, section 6 now.
Can I ask a question?
Good.
So on line 28, it says special flood hazard area. That used to be an A. Now that it's not because of the new FEMA 2.0 plan, is everybody going to be falling under that now, or how is that going to work?
Well, special flood hazard area is a FEMA term. And so they do on occasion, as you're noting, change it. So that's why we're using that term. So it will depend on how it is defined in any particular year. So this document should, follow along. I mean, like you're saying, that it used to be, we would call it a flood zone. Rick, you want to add to any?
Yeah, again, it's like Patty said, it's going to follow what FEMA's put out. That could change. Right now, a lot of that is 2.0, I think, driven, and as long as we're still working on that, that's what it's going to be for now, at least.
Thank you.
Question.
Rick and Patty, there was a question on if somebody has a prospective property right now that they're getting ready to list before January 1st, should they use the new form instead of the current one?
Myself, from a best practice, I would use the new form because I think the new form is significantly better than the one we're using. So I would, yes. And you can right now. They are all on the commission website. I think our digital providers hopefully should have them by this time next week, all, loaded and ready to go.
Right. And you can use it. And I would agree with Rick that is probably a very good idea to do, but you're not required to use it till January 1st.
Correct.
And you do not have to go through with every seller and do a new form at this time if you've already have those out there. You want to talk more about that, Rick? Because that's often a question.
Sure. Yeah, I mean, and ladies and gentlemen, I've been saying up to this point, hey, don't quite use them yet because we're still doing some fine tuning. But now everything's out. It's on the commission website. LR has it. You can use it now. If you send it to an agent, you want to use the form that both the buy-sell agreement or the proper disclosure document now. Send it to the other agent and say, hey guys, we're just using a new one. We're already getting started, so they won't look at you sideways.
Okay, great. Let's move on for now. And
yeah, just some formatting, nothing really there. Some contact info for HOA. That was just to kind of help, especially buyers if they need to contact and get more information from the HOA or any of those entities. Just some informational help there. Yeah, January 1 mandatory, but you can use them right now.
any other quick questions on the property disclosure document before we move on to the buy sell? Chris Nolan had a question on the exemptions on page 1. What's the difference between number 4 and number 7? So let's go back to the exemptions real quick. What's the difference between number 4 and number 7?
Okay, well, I will answer that. Number 4 is actually broader than number 7. 7 is pretty much limited to a succession, whereas 4 could be other kinds of administration of an estate, such as if somebody was ruled to be, we call it in the law, incompetent. They needed a guardian, and that a guardian was administering their estate, and that would be under number 4. The guardian might not necessarily have any information about the property that they are helping this person with. But number 7 would be in the course of a succession or a death where the property is being administered.
Great. Chris, if that doesn't answer your question, just fill it in. We can always go back to it. And I'm going to get to the section where we are moving on to the buy-sell agreement.
Okay. All right. So the buy-sell agreement. Now, I know if you have a copy of it, you're looking at it, the first thing you say is, gee whiz, Rick and Patty, man, y'all made an extra page. Well, we kind of did and we kind of didn't, but we'll get to that and I'll show you how. Anyway, so the first page, again, the top section looks a little bit different than what we're accustomed to. We basically took off fax numbers. Geez, I wanted to throw somebody in the bus on this call, but I won't because I don't know who's on it. But anyway, fax numbers we took off. You see a email address on both, listing agent, selling agent. And mind you, this is going to be the single entry email address for all notifications. You're not going to see it later on in the contract where you fill that section and check the box. This will be where all notifications come. So whatever address you put there, that's where notifications will be sent. And again, a lot of formatting there. The signature of designated agent, receiving agreement, comments section, a lot of that's the same, just a little bit of formatting. I will point out that the agreement transmitted by, we have a checkbox for electronic, and behind that you can put what kind of electronic means it was. If it was DocuSign, if it was email, if it was AuthentiSign, whatever electronic method you're using. Of course, we have a hand delivery option, and then we have another option. And behind that, you can put if it was delivered, via fax, or if it was FedEx or what have you, you can fill that in there. So we just made it a little more easy to put in some options, but you can check whether it's electronic, hand, or other. Good. Okay, so the bottom of page 1 is all your electronic notice authorizations. And basically this was taken from pages 7 and 8 of our current contract and put on page 1. And if any of you heard me before, and I know I've spoken about this ad nauseum, I use the same example, and Patty, you can help me if I'm misstating it. It kind of didn't make sense for a buyer and seller to agree to sign and have electronic notice authorization on page 7 after they've signed electronically 6 pages before. It's kind of like going in the checkout line, you check out half your groceries and they say, hey, this is a credit card only and you want to use cash, and you got to go back and start over again. That was the reason we put this here. Again, it was formatting. It just made sense to have that done right on the front section of the front part of the contract to get that authorization out the way. So that's why you see a little bit different looking page 1, but the reason is for that, so we can get that out the way first. But go ahead, Amy. The good thing is page 2, especially for those of us who write these contracts, is got the 3 most important things we like to look for: address, price, active sale date. I'll take credit for the formatting, although I really didn't do it, but that's just how it fell. So again, and I will point out, obviously, we did include some items there that we had a lot of comments on. And again, we take all the comments and go through them all. I can tell you online, in the window coverings, we included drapes that you'll now see on the contract, along with window coverings and hardware and all those curtains, everything else. We included drapes. We also included doorbells, because again, getting back to the security systems, a lot of people, Ring doorbells are in vogue. So sellers were taking them, replacing them with the push button doorbells, and the buyer saying, wait a minute, I wanted the Ring doorbell. So we included it. We also included all security systems and installed generators. For some reason, sellers would think that the whole house generator could be taken with them when they left. They can do that. They're going to have to exclude it. It is now included on the contract. The other thing we got a lot of comments about, of course, was attached television mounts. They now stay. You can take the TV, but leave the mount. And the rationale behind that was mounts are fairly universal. When a seller takes them down, they're usually big gaping holes in the wall, and they're not fixed. And so you can leave the mount, take the TV. Also gas logs on line 11 as well. You'll see that we have included those. And finally, most importantly, in the included section, we added a line 14 that all these items are transferred without any warranty. Okay, so if you included the garage fridge and some other things and the buyer takes them over, they didn't inspect them before, the seller's not warranting those things after the sale. So again, Patty, is that fair to say? Pretty Reader's Digest version of what we did there?
That is it. Again, I think best practices, if the Rings doorbell or something is very important to the buyer, list it in there that it stays. But we tried to cover as much as we could in just the basic what goes with the transaction.
There is a question if that includes the Nest thermostats.
So the question would be, is that a component part of the house? And would it be considered by a reasonable man to go with the house when you buy a house? And would it cause damage to the house to remove it? So I'm not as familiar with the Nest thermostat and how it's removed or input, but again, I would say don't leave it as a question, list it as something that stays with the house if that is important to your buyer, or something that goes if that is important with your seller to take with them.
And again, the best practice, if it's more important to the seller, then have them take it down and put up the old type thermostat before you even put it on the market, because inevitably somebody's gonna come in and say, hey man, I love that Nest thermostat, thank you so much, and they're gonna expect it to be there. So I would take care of it beforehand if it's that important to the seller. Okay, Amy?
Let's see. Let me catch up on a couple of
Sure.
questions here before we get too far along. So for clarification, the name of agent receiving agreement and the signature of designated agent receiving agreement, is this the printed name on the first line of the listing agent and then signature of the listing agent on the second? That is a question for clarification due to the fact that it has been confusing previously.
So the name of the receiving agent, that would be somebody other than the designated agent. If it was dropped off or brought to an office or brought to a front desk, they could sign it or receive time and date. The signature of the designated agent receiving the agreement would be in fact the listing agent.
Okay.
And that they would annotate there on that line. If the designated agent is getting it directly, then you wouldn't have a need to use the name of agent receiving it. There would be no need for that. Is that, Patty, is that fair?
Right. The idea is to be able to track how this agreement gets delivered.
Right.
And sometimes it has an extra link in there.
Yeah, and we kind of left it kind of, for lack of a better term, old school for, in fact, the hand delivery. If you bring it to someone's office and as an agent on desk, it's not necessarily the listing agent, but it is an agent. They could sign saying, hey, I received it, great, but I'm not the designated agent.
Okay, and there was a question about what's the difference between the listing firm and brokerage name?
And I'll answer this. Listing firm typically would be what we're more familiar with. I'm trying to use an example. Like for instance, for my firm, that would be Coldwell Banker Tech, and you know, the brokerage name might be Coldwell Banker, the Ernst Corporation. Again, it's not terribly significant. We put that in there for some clarification when there's multiple franchises. So for instance, like Keller Williams, you know, to distinguish between Keller Williams, you know, 504 brokerage versus Keller Williams real Red Stick Partners. That is the idea there, especially if there's a multiple office situation.
Okay. Does line 4 still include the legal description?
Yeah, yes. The number and the legal description would be in that blank there. If you have any, you know, grounds measuring, and if you want to put whatever the legal square and lot is, you can put that there. Yes.
Mm-hmm. And also note, and this doesn't show on the slide, but at the top of every page, there is a line to put the property description, and that you can do lot number or you could do municipal at the top and the date. With the quick turnaround in the current market, they said that sometimes it was getting very confusing on what all went with what. So there is actually a line at the top of every single page where you can put that in, and you can autofill that to every single page.
Okay. So there's a lot of questions regarding cameras and doorbells and all of that. And I don't want to get too bogged down in the details of, you know, how that gets stayed or what's considered that. We do have an article that Patty and them had produced regarding component parts and non-component parts that I think will be helpful. And I can drop that in the chat. And then what we'll do is we can circle back around and kind of take a deeper dive into what those things are and maybe produce kind of like a frequently asked questions or some sort of supplement that you can kind of go back and reference that portion to. I think it's important to just add that a lot of those things were taken and added into this piece. Best practice would be, if it's important to your buyer or seller, to make sure you annotate that within your agreements. Is that safe for now? And then that way we can kind of go on.
Sure.
And then one other question, if the agent how will the agent submitting the offer be able to indicate when it was sent to the listing agent, since sometimes there's a gap between when it was sent and when it was received?
Amy, is that if a receiving agent gets it and then the time between the receiving agent gets it and when they get it to the designated agent? Is that the question?
Well, you know what? Now that I'm seeing the question, I think it's that's on submitting an offer. So not necessarily as it relates to the form.
Okay.
So let's move on with the purchase agreement and then we'll circle back around to that.
Okay, so mineral rights section, of course, again, this is a statewide contract. It's more important to some areas of the state than others, but we did not only highlight it and place it in a box, we added the buyer and seller lines to it. We also added, percentage of the mineral rights that are reserved and retained. And again, some formatting there, but we did highlight that. So buyers and sellers are signing specifically in there. If there's any transfer of any kind of mineral rights, they will acknowledge that there.
And will sign there.
So, right.
And there's more blanks so that more buyers and sellers can sign. So
Yeah.
hopefully it will be easier to use.
And one footnote there too, Patty, you must not make your slide. On the final version, there are 4 buyer and 4 seller spots in that box for mineral rights. Okay, deposits. So line 119, you see a line for no deposit. And again, I've gotten a lot of both pro and con on this. You don't have to use the box. You can surely still take deposits, but if you choose to do no deposit, you can check that box. It's just an option like anything else. On line 20, we still have listing broker, selling broker, but instead of checkbox for third party, we put other, and the thought behind that is there's still a requirement now to have the deposit addendum attached if it's an other, which anybody other than listing or selling broker would be other/third party. But you can fill in on the contract who that other is. If it's a title company, a specific title company, if it's a builder, if it's a specific name of someone, you can see it right there on the contract before you even get to the deposit addendum. So that was the thought process there. We just expanded, changed up the other third party to other, and put a line so you could fill in behind it. Okay, property condition, we did change up the name, and that'll be carried. We can go to the next slide, actually, Amy. We did change, we have a new acronym now, folks, in case you hadn't heard, the DDI period, which is due diligence and inspection period. This is the most salient change on the contract, members, and separate apart from anything else, the change here is basically this. The buyers, if you're working with a buyer and they have X amount of days to make a response, when you have one single response you can submit to the seller. When you submit that response, if there's any more remaining days, those days are lost. 72-hour period starts either when you submit the buyer's response or the number of calendar days has in fact expired, whatever those number of calendar days was. That's when the 72-hour response time starts for the seller. We went back and forth on this. It just made sense that a seller would have some solace in that once the inspections are done, they get one single response for a list of repairs or remedies or concessions or whatever was being asked for the buyer. And they knew that they would not get another response on day 8 or day 9 or day 10. Once that response is submitted, that's it. Now, again, it's probably not a big sea change from what we're presently practicing and doing. However, now both buyer and seller agreeing to it right here on the contract. So Patty, anything you want to add there? Is there any other takeaways there?
Yeah, so DDI period includes not only your physical inspections of the property, whatever you're going to do, but also if you wanted to look at school zones or you wanted to look at those kind of things. So don't think just because you've done your property inspection, but you haven't looked at the school zone, that period's going to continue for you to look at the school zone. Once you submit that buyer's request, that's it. All inspections and all just due diligence that you were doing looking at things like school zones is over. That period is finished.
And we did not change anything with regards to the due diligence period. You know, you can still inspect for insurability, flood insurance, flood zone, you know, any kind of anything that affects the property or affects the surrounding areas, whether it's school district or square footage, anything regarding the property would be covered in that DDI period. And really a best practice, members, is if you, for argument's sake, have 10 days and you think you've done all the inspections and the buyers may be considering one more, you might say, hey, wait, look, before we submit, make sure we're not want to do that one inspection. If we're going to do it, make sure it's done before you submit that one single response. That's just the best practice. So that is the most salient change on this current contract that we're using, which is regard to the inspection period.
So a couple of things that I would just want to note on everybody. So what you might see here on your screen may be slightly different than the version that you might have just downloaded from the Real Estate Commission's website. I wouldn't get too bogged down on the actual line numbers here, but look at the context so that you can make sure that those things line up. Just because from a formatting perspective, what you see on this screen and what they're referencing might be a separate line number on the actual form. The Real Estate Commission's website will always be the most accurate location of where you're downloading those forms. And so as you're trying to understand that, certainly reference that to look at it, but it may not be lining up exact. So I do want to point that out.
Amy, I see a question regarding getting insurance quotes and flood. I mean, again, a best practice, especially in the times we're in now with Flood 2.0 and all the other things going on there. If you have a contract that, and before the ink even dries, you call on your home inspector, AC, pool, and you call on your buyer's insurance agent and having them run the insurance, both flood and homeowners, to make sure you're covering that in a DDI period, because that's the time to do it, not after.
Okay. Okay, so on the response, what if you asked for additional time in order to do another inspection, like a foundation, or do you have to do an addendum to the contract?
If you're gonna increase the number of days for due diligence inspection, absolutely yes. And all parties would have to agree to that. Patty, I don't want to get legal.
I would agree.
Okay.
Yeah, if you're changing what is in the contract, you've got to do that in writing, and that's going to be an addendum.
And all parties would have to agree to extend.
That's right, both sides.
Okay.
I have a question on that because we had this in our meeting this morning. What if somebody sends you a property inspection response on a Friday and the 72 hours ends on Monday and it's just impossible to get what you need done in that time, or over a holiday period?
I mean, you know, that's a tough one too. Obviously, we don't try to put anybody in a bind, but yeah, it's tough. And that was the original, forgetting holidays, but that was the original thought when we first put the contract together, the 72 hours. Because if you got on a Friday, Saturday, Sunday, hopefully that would give you a Monday to call in an expert, AC person, pool person, whatever, to refute or substantiate whatever was submitted. But on a holiday, probably you're going to have to ask for some extra time if it's just an odd time or you're having trouble, especially now we're trying to find vendors and and folks to look at different components of the house, you probably have to do an extension or ask for an extension of time.
Okay, so when the property inspection and due diligence are running simultaneously, do you have to hold the buyer response to the property inspection until due diligence is completed?
Yes. There's one period to do all of those things, and it starts at the same time and it ends at the same time, whether it's an inspection or a due diligence item like determining flood insurance requirements.
Okay,
Not two separate periods.
okay. Let's see. What about WDIR agents? They continue to want this done within 30 days of closing. Do you know what that?
Yeah, the wood destroying insect report. That used to be a more contentious item because lenders were requiring a wood destroying insect report, or what the term is usually a termite certificate, for lack of a better term. But I don't know if many lenders are even requiring it right now. So the 30-day date on that, if you're getting it during the due diligence inspection period, most lenders aren't requiring. If I had a buyer, I would get one during the inspection period because I want to know right up front if there's a need to treat the house. I'd want to get that done beforehand and get that resolved in an inspection period and not wait till you're within that 30-day range of closing. So it used to be in vogue. I don't think it's as important now, but I would get it done during the inspection period.
Okay. All right. So do y'all want to go over the different options on that period? How do you want to do this next section?
We can. I think that the biggest takeaway here, Patty, and jump in anytime, is what we have here. And again, like I started, hey, Rick, we made 10 pages, but really we didn't. What we did is expanded the options. And instead of having one big muddled paragraph like we have now to see what happens if the seller doesn't respond or the buyer doesn't respond and what are the options, we've spelled those out a little bit more clearly, both for us as licensees and for our clients on page 6, which is the slide you see in there. It is exactly the same as how we're working now under the current contract, the 72-hour periods, what the buyer's rights are, what the seller's rights are, if they respond, if they don't respond, all that has remained unchanged. It's just been spelled out more clearly for both us and our clients. So, and again, I'll refer back to Patty's flowchart, the colored flowchart, which is also available on the commission website, which helps kind of guide a prospective buyer and or seller through what happens, and they can follow right now to see what happens if they made a response and the buyer doesn't respond. What are the options? So, I mean, we could, based on the questions, Patty, I don't know if you want to chime in there, but we really didn't change anything. We just spelled it out a little bit more clearly.
That's right. The intent was not to make any changes to that, but just to more clearly represent what the options were for every party, buyer and seller, with each phase of the process. Of course, the easiest one being the buyer makes their inspections and they love the property and say, let's go forward. But if that doesn't happen, then you have the buyer making a request, and then you go through that series of request and response and hopefully resolution of those things, and you end up at closing. But this is the chart, and that you'll see red, a red box means things did not go well and you're not going to closing. There was a termination, and green means you made it successfully through the chart. But it looks a little bit intimidating, but when you read it, the choices make sense to what a buyer or a seller would have an option of doing. So I hope it will be helpful.
Okay, so let's
But I do think this slide is important. Just remember, only one request. So that is a big change. And when you in the request, when you make the request, that ends that inspection and due diligence period.
Okay. What happens if the buyer does not submit an answer at the end of their inspection period?
If they don't submit an answer or don't submit a termination, then they're accepting the property in its present condition and moving forward.
Okay.
It is spelled out actually, lines 191 to 193, I believe. Patty, check that for me, but
Yeah.
failure of the buyer to timely provide written notice of termination of buyer's request as described in lines 202 through 250 prior to the expiration of the DDI period shall be deemed as acceptance by the buyer of the property's current condition.
Mm-hmm. And again, I caution you, use the forms off the LREC website, because we did this presentation a few days in advance of it getting posted and finalized on the website. So the line numbers may vary a little bit. The actual information is the same. The only thing that's changed is the line numbers they changed as we went through with formatting and those types of things. So look at the actual reference on the LREC website, and the chart that's on the LREC website should match the final version. So hopefully will be helpful to you.
And I just put the chart in the chat. When does the 72-hour start? When it's sent by the agent or received by the receiving agent?
Let's see.
Sent by the agent, Patty, unless you tell me otherwise.
Yeah, I'm looking for the language in here,
Yeah.
but it says, like for instance, the seller's response to the buyer's request. So the buyer has requested some revisions to the property. I want the roof fixed. And then the seller's response, and it says the seller's written response shall be provided to the buyer within 72 hours of receipt of the buyer's request. So it's when the buyer gets it. And that could be through their agent.
Right. Okay.
Okay. We're gonna move on to the next section.
Okay. Basically, just again, one new question. We noticed private water systems had been, we didn't have those in there. We had private septic treatments, there is no, but we didn't have, there is no private water servicing the residents. So we just added that. Again, basically formatting. If I could point out one other real quick thing, Patty and Amy, anywhere there's a spot, and I'm just, if you're looking on the slide, anywhere there's a spot for a entry for numbers, number of days, number of systems, number of curative days, you're gonna see in two spots. The first spot would be an alpha spot where you would write out, for instance, 9, N-I-N-E. Behind that, you'll see a number sign, which you'd put the numerical representation there. Again, in digital format, it's really not that critical. However, if somebody is handwriting or something of that nature, sometimes a 9 can be confused with a 5 or a 7. So this way you have an alpha and a numeric spot. And we just thought that was better for clarification. I think Patty maybe suggested as well that it's typically done in legal contracts. So we just followed suit there. Patty, is that fair to say?
That is true. And I'll just tell you, every once in a while, and I've gotten this many times with the hotline, what happens if someone writes out with the alphabet 7 and then puts 5 in the blank? So that's unfortunate. You should definitely try not to do that. But if it does happen, what's going to control is what is written out with the alphabet.
Yeah, that's what the bank uses as well, I believe. Huh?
Mm-hmm.
Mm-hmm. Okay.
Oh, here's the flow chart.
Again, members, I tried to take credit for it. Patty's on the call, so I can't do that. But again, thanks to Patty. And I believe her husband, right? Is that right, Patty, who did the...
That's right. My husband helped when I said I needed help with the flow chart. He got excited because he's an engineer and this is something that he definitely knew about. And he related it to a distillation column, if that's helpful
Oh
to
my God.
anybody. But yes, he was very instrumental in helping me do the graphic there.
That's way above my pay grade. So thank you, Patty, and thank your husband, please, for that.
So I'm just going to highlight real quick. This is on the Louisiana Realtors webpage. If you want to kind of do a general quick overview of what the changes were, there's a great YouTube video that apparently has been viewed quite a bit already. If you want to do a quick rundown, we've also provided a full detailed legal line article that will help you walk through the actual red line changes. And I encourage you to take the time to go in through that and look at these full legal lines and see the comparison between the 2020 version and the 2022 version so that you can familiarize yourself with what these changes are. Let's see. So we have both the property disclosure document as well as the buy-sell agreement there. The recording from today will also turn up on this page as soon as that's done. And let's see, we're right at that 45-minute mark. So what we can do, if Patty and Rick, y'all are okay to take questions for a little while longer, we can kind of go through the chat and look at that and address some of those that maybe have not been listed.
Okay.
So let's see. Angel, there is a YouTube video of it. I would just advise you to go to LR's page right in front under news and events. And this changes to the residential buy-sell is right there. And you can access the YouTube video on that as well as the full in-depth legal lines that will show you the red line versions. There was a question earlier. Let's see. So with the inspection period, so the example is you have 10 days in order to do an inspection and you get the home inspection done in 3 days. And if you go ahead and turn in the response to the listing agent as soon as that's possible, does that mean you are giving up the remainder of those days?
Yes, unequivocally, yes. Yes.
So Barry, I hope that answers your question. Now
Sorry, Patty, I didn't wait for you on that one.
Nope, absolutely. That's exactly right. It is.
Right.
Okay. And let's see. I do not see a place for sending agent to annotate on page 1 when the offer has been sent. No signature, that is only day and time it's been sent.
Okay, for the sending agent to annotate their own offer?
I may have missed. I do not see a place for sending agent to annotate on page 1.
Well, the sending agent wouldn't
when the
annotate.
offer has been sent. Yeah.
Well, they're writing the offer, so they don't annotate their own offer. The annotation would come from the designated agent or whoever the agent is receiving it. Now, again, if you wanted something time-stamped or something of that nature, a best practice that I typically do is if I'm emailing it, I'll blind copy myself. So I'll know that it was sent at 3 o'clock Wednesday afternoon. And again, if you get the contract back from the designated agent and it wasn't annotated till 3, 4, 5 hours later, well then you know how long it's taken. So the sending agent wouldn't necessarily annotate their own offer. It would be the annotation coming from the receiving agent, if that makes sense.
Okay. Lydia, if it doesn't, I would just clarify that, but how long does an agent have to sign in documents? How long does an agent have to sign in documents? Purchase agreement, buyer's response.
I'm sorry, Amy, read that. How long does
an agent have to sign in the documents?
like maybe annotate them, maybe? Is that what they're asking?
I don't know. Allison, you might want to clarify that. on the last page of the purchase agreement, which agent signs where. I have had different agents with differing opinions.
Okay, all right, so I'm assuming they're referring to where the offer was presented to the seller or buyer. So again, if I'm the listing agent, I receive an offer, I would sign just under the buyer's printed, in that first section, the offer was presented to the seller by me, and then indicate the time and date. So I've annotated on the front page, I've received it at 3 o'clock, but maybe I didn't present it to the buyer and seller, or I'm sorry, the seller till 4 o'clock that day, and then have a day and time. So that would be the first response there. And then if there's an acceptance or a rejection, or a counter for that matter, and I send it back, then the buyer's agent would sign there at the very bottom saying they presented it to the buyer at a certain time. So there's 2 spots there, one for the listing agent receiving it when they present it to the seller. And then the second spot is whatever's coming back, whether it's acceptance, rejection, or counter, when the buyer received that, when it was presented.
Okay.
Hopefully that explains.
How would an agent, let's see, how would an agent submitting an electronic offer be able to indicate when it was sent to the listing agent? Since sometimes there's a gap between when it gets sent and when it was actually received.
Okay, that's a good one. And again, I'll tell you best practice, if you want to know exactly when the designated agent receives, a listing agent receives it, I would send it to them via DocuSign or AuthentiSign. And that way, and you could text or call or beforehand and say, hey, look, I just sent you an offer, check your email. They check the email. As soon as they open that email and view it, you get a timestamp signature email saying so-and-so has received it or viewed it, I'm sorry. And then when they annotate it, when they sign it via DocuSign or AuthentiSign, you'll get another email saying document's been complete, and you get a copy of it. So that would be your best practice there. You'll see not only when they viewed it, but when they've actually annotated it.
Okay. Some of these others are more statements. I don't know that they're questions.
Okay.
Patty, Rick, do y'all have any closing thoughts, comments?
Can I, this is Lydia here. I'm sorry, guys. I'm still confused though. On page 1 of our existing contract, unless we've done it wrong for all of these years, we've always signed as the sending agent. And then there's a spot for signatures of the receiving agent. So you have a delivered by designated agent, 2, and that's where you would list the agent you're sending it to. And then you have a received by. So I heard the answer, but I'm not clear on, you said, why would a sending agent sign? Well, we've always signed.
Yeah, well, no, we do not include the delivered by designated agent line 2. Again, with the advent of electronics and DocuSign, again, best practice, we did not include that. So all you have is the receiving agent annotations there, not the delivered by designated agent 2. No, that would go to the name of the receiving agent if it was delivered to an office and not done via either DocuSign or some electronic format.
Okay, I would like to ask this question about the lease portion of this document.
Okay.
All right. So right now it's reading that you have 5 days to notify the buyer of an existing lease. And then the buyer has 5 days to respond, whether they're going to accept it or not.
Right.
The difficulty, I'm going through a situation right now. The difficulty on accepting a current lease is you have no knowledge of the lessee. The seller has knowledge, but you, the buyer, have no knowledge. So to me, it would seem that you should, in that disclosure of it, include the lessee's lease application, as well as their rent payment history to the seller during the term of the lease. So then you can decide, yes, I want to accept this person, or I don't want to accept this person. In other words, if they're pushing off somebody on you that is typically late on their payments, you need to know that.
Right, and I'm gonna let Patty chime in. My thought would be this. This gives you opportunity to review the lease. If you wanted to further do your due diligence, if you will, on, rental payment history of that sort of thing, that surely could be covered in the due diligence period to say, hey, look, supply us with, rental or in the body of the contract. If there's multiple leases there and you're unsure of how their payments, if they're paying on time, that sort of thing. Commercial covers this. I don't want to get into it, but with estoppel certificates and that sort of thing, which basically covers, hey, are they paying on time? How do they pay? That sort of thing. So we really didn't address it specifically, what you're talking about, Ann. But again, this contract does apply to up to 4 family homes. So it could be significant. Again, Patty, unless you have something to offer, I would say that can maybe be addressed either on the contract or surely during the due diligence period.
Well, let me just mention something. The problem I'm currently having is that this lease was not in the MLS and was not disclosed until 5 days after acceptance of our contract. So we had no clue they even had the tenant in there.
Well, if you're still in your due diligence period, I mean, that's a slippery slope for the seller to go on, because you could cancel your contract based on that alone, if you're in your due diligence period.
But we have chosen not to. But the reason I'm bringing it up is that the way this is written, we need to have a little bit more detail, like we need to basically say, if you are releasing this lease to us, we need the accompanying documents, because you can't really, you can come back and say, I was basically told, oh, they had no lease application. Oh, they paid fine, but this lease was signed 4 days before they listed.
Right.
So,
and the only thing I can suggest is if you get it right on the front end and put it right in the contract, that's one of the terms of the contract, is they provide you with rental payment history within 24 hours of acceptance. No different than if you ask for a lender letter or something of that nature. That way you can get it right up front. If they in fact have it, they're obligating themselves to supply it. And then you have your whole due diligence period to scrutinize whether it's real or not, and go through that. But that's probably the only thing you could do there, especially if you have multiple leases, is to get it up front on the contract.
Can you clarify whether the legal description needs to be filled in?
Where?
It does need to be filled in, and there should be a blank form.
It's on line 4 for this, correct?
Legal description goes on line 4. Okay. Okay, guys, I want to be respectful of everybody's time. We are right at that hour. I think we've addressed a lot of the questions.
The legal description, there's no place for the legal description.
It's missing the line.
I think it may be missing the line. I think you may be making a good point about that. I was just looking at it. I'm not sure and what happened there, but there's a description for legal description in parentheses, and there was a line before that, and I think somehow it's gotten deleted when it went up online. So we'll look at that and see if that needs to be clarified.
Also, will the buyer's response to inspection be updated since y'all are changing the due diligence period?
Yes.
And the inspection period?
That is in fact online as well. Yes.
Okay, thank you.
Yes.
Okay.
When do we think these issues will be remedied and the new form uploaded?
It's just missing, it looks like part of a blank, Rick.
Yeah.
So I don't know how long it would take the commission to just make that little change.
What,
I don't even see an area for the legal description. I just see the measurements of the lot size on mine, what I just downloaded.
yeah, it's missing the word legal description, actually. That was on there before. Everything else is exactly the same. It just doesn't have a legal description in front of that line.
Okay.
So-
Okay, it says lands and grounds measuring approximately, and then the number sign and a blank.
Right.
So I don't know where legal description goes on what I just downloaded. But
So look on,
On our present contract, legal description is right before that, in front of that.
right.
okay. I was going to train on it tomorrow in our weekly meeting, so I was hoping it was going to be the final that I could pull, but I'm guessing I need to hold off on training on it.
Well, you can train them on the rest
You
of it
can-
because there's nothing else going to
You still
change
can
there.
train. It shouldn't be any problems. We can work through getting that
That's formatting, that's not a
corrected.
substantive
Yeah.
change. Yeah, that's. not-
Yeah, we can get that corrected on the Real Estate Commission's website. Again, if y'all have any further follow-up stuff that needs to be looked at, I think the best way to handle that would be to send it to info@larealtors.org. I did share where on Louisiana Realtors website you can look at this and the previous recording that we've done and a more legal and in-depth red line review of those changes so that you can kind of go back, and if there's a particular section that you want to go back and take a look at, I would encourage you to also go back and read that component parts article. That was one that was really hot topics for a while, and based on a lot of the questions regarding doorbells, thermostats, and all of that, you can certainly go through that. And always reach out to us if you have any questions. Thank you, Rick. Thank you, Patty. Thank you to everyone that worked hard on updating these forms. And everyone have a great day.
Thanks, members.
Thank
Amy.
you.
Thanks, Patty.